Well, 6 witnesses took the stand today in Jennifer Crumbley's trial despite a late start tied to that bad weather. A standout moment came from one of Jennifer's former co-workers. Amanda Holland said on the stand that Jennifer told her the family had gotten into a fight the night before the shooting. Crumbley's defense quick to respond during cross-examination.
But she said that Ethan was out of the house and she locked him.
She locked him out of the house?
Yes.
You don't know anything about him being locked out, any details beyond him that there was a claim he was locked out?
Correct.
So you don't know if he was locked out because he made an accident and left keys in the house, or if Jennifer Crumbley intentionally locked him out? You don't know the context around any of that, correct? I'm sorry?
I don't know.
Holland testified she was surprised to see Crumbley come back to work after there was an emergency meeting the day of the shooting addressing her son's concerning doodles on a math assignment. We have a lot to get into tonight. Again, 6 witnesses on the stand today. So let's bring in trial attorney Johnny Hawkins. Thanks so much for being with us again. We always appreciate your perspective, your insight on this. I want to talk about a key moment. Jennifer made it sound, or at least her defense attorney, Shannon Smith, made it sound like the Crumbleys could not take the shooter home from school the day that they had the emergency meeting because both parents were working. Sounds like dad did DoorDash, but Jennifer's previous boss took the stand. In his testimony today, he said, "We have a family-friendly environment. She's worked from home in the past. She could have brought her son to the workplace." How damaging do you think that was to the jury?
Unfortunately, extremely. Those are what we call mitigating circumstances, meaning it reduces the likelihood that you can or cannot do a thing. They had all the abilities in the world, meaning they had options. Most of us don't have options, meaning this wasn't a factory worker and or a surgeon, right? This was a person that was doing DoorDash and then his wife. It doesn't make sense. It didn't make sense to me, and I'm sure that the jurors are really scratching their heads like, wow.
You have a lot of experience being on the defense side of things. In her defense, could you make the argument that just because the boss says it's okay, that maybe you don't feel it's okay at the moment? Just because maybe your boss would be understanding doesn't mean you push the limits or you see what you can get away with and you ask to work from home.
I still say no, unfortunately, because we're talking about a parent who has been advised that her son is in trouble. This is your child. So when you have a chance to help, you do. So in this instance, if your boss is going to be okay with it, of course you're going to do it. But even if the boss wasn't, who comes first? The child. So
we saw 3 law enforcement officials take the stand today. Among the evidence that was shown during their testimony, some photos of the Crumbley home. And I think disarray is a fair word to use. And the investigators made it sound like they got there promptly. That search warrant was executed very quickly. So this was the natural state of the home. These weren't photos after it had been ripped to shreds. What did you think, just that environment? Did it represent their kind of parenting or the family dynamic, seeing photos of his 2 bedrooms, some of their common spaces?
It didn't serve them well at all. Again, I'm a defense attorney, so I'm hoping to see better coming of this, but today was extremely damaging. Our houses represent who we are to a degree, right? Our cars, our dress. So I wasn't expecting to see that as a person looking from the outside looking in. When I saw that as an attorney, I was like, whoa, juror, man, she has major problems here.
Okay, we briefly spoke right before this segment started, and you're comfortable talking about this, and for that I appreciate it so much. Some people have said the defense attorney in this case, Shannon Smith, isn't doing a very great job. And people are really trying to figure out, when you start your opening statements with Taylor Swift lyrics, I mean, there are just some key moments that take people aback. They make them wonder why. You have said you've wondered if this is intentional for an ineffective assistance of counsel claim after the trial. How did you come to that? What is making you think that that could even be a possibility?
I shrugged a little bit as you said that, because I'm not saying that counsel is doing this intentionally. I'm saying that if I am the defendant, that this is something I'm definitely going to think about, because after this is all said and done, if I'm convicted, people are going to be talking to me. And guess what? That is a last-ditch effort to say, hey, I was found guilty, but it wasn't because of anything I did. It wasn't because of the evidence. It was because my counsel was ineffective. As a result, I want this matter to be looked at again, and I want to appeal based on my theory of ineffective assistance of counsel. I could have done better. She could have done better. She clearly did not from the start. And now here we are. And I'm guilty, and I'm going away for 15 years. That's a possibility.
Do you think that's something that's in the judge's mind? Because for me, having watched this trial day in, day out, it does seem, sympathize might be too strong of a word, but it appears the judge has been very patient with the defense, very accommodating with their objections. Do you think that this is something maybe in the forefront of her mind that she wants to counteract if it gets to that ineffective assistance of counsel point?
First of all, the judge is doing an amazing job. I think she's doing great, but I don't think she's thinking that. No judge would think that and then allow that to go on in their courtroom. I think she's just being, she has a good temperament, a good disposition, and she's working with what she has, that being this attorney, this defense counsel in these circumstances. So I don't think the judge is thinking it, but I think it's always a possibility now that we're seeing what's going on here. It's just, I think it's catastrophic, and that's something we say in personal injury cases. This is catastrophic what I'm seeing before my very eyes. I'm concerned.
Your personal opinion, you were rooting for the defense in this case, correct?
Yes.
Is that safe to say?
Yes.
Okay. Knowing that that is where your heart is and the outcome you've hoped for, do you think the prosecution has it in the bag?
They 98% do, if you ask me. But again, as Arnold Reed said earlier today, we got one shot. That's with the defendant. I agree with him, as did Rick. And the bottom line is all we need is one juror to say, no, I disagree with everyone else if you want to convict her. That would be a hung jury. They'd have to start over. So we got one shot.
Last question for you. Do you think with how things are kind of leaning in the prosecution's favor right now that they should trim back on witnesses?
Absolutely. There's no need. Rick and Arnold both said this, and I agree. Look, they're putting on a great case. Better than I thought they would be able to, given the actual charges. Why go on? I think it's pretty sure. I turn it over to the defendants at this point and let them do their thing.
Okay. Again, trial attorney Johnny Hawkins, thank you so much for joining us. Appreciate the insight. Can't thank you enough.
No problem. Thanks, Michelle.